Hello students, welcome to SRIRAM's IAS. Welcome to this PYQ series. Every day we come up with PYQ of different subjects. So we are going to see polity again, and let's dive deep and see what is there for us in Indian polity. Now the question are mix of so many other topics. They are not related to fundamental right or directive principles of state policies only. We have to see other topics also. So center-state relationship, emergency. The questions today would be from many topics. So the first question is about which one of the following suggested that the governor should be an eminent person. So the question is about governor. Should be an eminent person from outside the state and should be detached figure without intense political link, or should not have taken part in politics in the recent past. So everything which was said about governor, okay, to maintain the balance between the center and the state, all those things were said by the Sarkaria Commission, were recommended by the Sarkaria Commission, and hence this is the answer here. Answer is option number C. Coming to the second one, consider the following statement. According to the Constitution of India, the central government has a duty to protect states from internal disturbances. So, if you read Article 355, Article 355 clearly tells that it is the duty of the central government to protect the state government from any kind of disturbances, internal disturbances also. So do not confuse this word internal disturbances, since this was removed from Article 352 and was replaced by armed rebellion. So we are not talking about the grounds on which emergency can be imposed, proclamation of emergency can be imposed. Those are different things. War, external aggression, armed rebellion, those are different things. Okay, you must not think about that. This is different. We are talking about protection of the state government by the central government, and if there is any kind of disturbance, internal disturbance, then the center can protect the states, and this is done under Article 355. So this is the true statement. The Constitution of India exempts the state from providing legal counsel to a person being held for preventive detention. Now preventive detention is mentioned in Article 22 of the Constitution. Article 22 of the Constitution gives right to the person who is about to get arrested or has got arrested. For example, if police arrests or any investigating agency arrests a person, the person needs to be told the grounds on which the person is getting arrested. What are the charges framed against him? What are the grounds on which you are arresting him? And the grounds have to be told immediately. It is not as if the police is taking 5 hours to tell the ground. That simply means it is the curtailment of the civil liberty of the person. Why? For the simple reason that you cannot go and arrest the person on any unreasonable basis. There has to be some reasonable basis, and if there is a reasonable base, then immediately you should convey the grounds on which you are arresting that person. It's important for you to understand. Immediately it has to be done. Then if you are taking the person to some location, okay, the location needs to be told to the kins, the family members of that person. Then the person should also be given a legal representative. If the person has been arrested on false charges, on false ground, how the person is going to protect himself? He protects through a legal representative, and the legal representative must be given. So these are all protection given under Article 22 of the Constitution, but at the same time there is an exception also, and the exception is the exception of preventive detention. What is the exception? That if a person, on the assumption that he may cause disturbance or law and order problem or security problem, then he can be arrested. So that is what is preventive detention all about. So this is mentioned in article number 22. And when it comes to preventive detention, legal counsel is not necessarily to be provided. It is the discretion of the state to provide a legal counsel or not. Okay, I hope you are getting this. So the statement says that the Constitution of India exempts the state from providing legal counsel to person being held for preventive detention. This is true. According to the Prevention of Terrorism Act 2002, confession of accused before police cannot be used as an evidence. So, if you understand this closely, the Indian Evidence Act, there is a provision in that Indian Evidence Act that any statement made by an accused in front of the police is not admissible in the court of law. Okay. But this particular act which was passed, POTA Act, this was called, Prevention of Terrorism Act of 2002, allowed the statement made in front of the police to be admissible in the court of law. But then this act was repealed in 2004. This act was repealed in 2004. So according to the Prevention of Terrorism Act, confession of accused before the police cannot be used as an evidence. Yes, this was true, but at that point in time. Now it does not exist. So those two statements are correct. Moving on to the third one. Which of the following are not necessarily the consequences of the proclamation of President's rule in a state? What does not happen? Let's see. Dissolution of the State Legislative Assembly. Not necessarily dissolution. The assembly can only be suspended for a temporary period of time. Okay. Only suspension can take place. There is no dissolution at all. So there are two options in front of the governor, either to dissolve the assembly or to suspend the assembly. And the governor cannot dissolve the assembly on his whims and fancies. There has to be some reasonable ground to do it. Because once the assembly is dissolved, then the election has to take place again. There has to be a re-election for the new for the new legislative assembly. Okay. So dissolution is not necessarily the only way out. For a temporary period, there can be suspension of the assembly also. Removal of the Council of Ministers of the state. Well, this definitely happens. That is why it is called as President's rule. Because President always works on the aid and advice of the Council of Ministers. And when the Council of Ministers is not there, then it is the governor who is the in charge. Governor, it is the president who is taking the power, or the parliament who is holding the power of the state legislatures, and through them, from them, through the governor, the power is flowing. That is the reason why removal of Council of Ministers is a necessary ground under 356. Dissolution of the local bodies. So there is no effect on the local bodies. Okay, so these two does not happen, and that's what they are asking. So 1 and 3 are the correct answer here. Moving on to question number 4. If the President of India exercises his power as provided under Article 356 of the Constitution of India in respect of a particular state, then what would happen when the President uses Article 356? The assembly of the state is automatically dissolved? No, we have just now seen either it has to be dissolved by the governor, or it can be suspended also. So this is not the correct option. Second one, the power of the legislature of that state shall be exercisable by or under the authority of the parliament. Now this is the correct statement. This is the right statement. It is the parliament who looks after the powers of state legislature once president rule is applied. Article 19 is suspended in that state. So there is no effect on the fundamental rights when president rule is imposed under Article 356. For the failure of the state machinery, that's the ground on which Article 356 imposes the president rule. So there is no effect on fundamental rights. Article 19 is suspended when national emergency under Article 352 is imposed. If that is imposed on the grounds of war or external aggression, only then Article 19 would be suspended automatically. If the national emergency is imposed on the ground of armed rebellion, then again Article 19 is not suspended. So suspension of the fundamental right, now that criteria has to be seen from the prism of national emergency, Article 352. Okay, here Article 356 has no effect on the cancellation or suspension of any fundamental right. Fourth one, the president can make law relating to the state. Yes, the president can make law, but it is the parliament who authorizes the president or some other authority to make law for the state during the emergency under Article 356. Okay, so statement number 2, this option number B is the most accurate one, and this is the answer. Consider the following statements. If the election of the President of India is declared void by the Supreme Court of India, all acts done by him in the performance of the duties of his office of President before the date of decision becomes invalid. Now this is not a correct option. Why? Because the President always works on the aid and advice of the Council of Ministers. So even if the election of the President has been suspended or has been declared as invalid, the decisions made by the President were the decisions of the Council of Ministers only. So whatever decisions which has been taken by the President will not be declared invalid. It's an important thing for you to understand. Okay, any decision made by the President, and if the election is declared void, those decisions will not become invalid. They will be valid. Okay, moving on to statement number 2. Election for the post of the President of India can be postponed on the grounds that some legislative assembly have been dissolved and election are yet to take place. Again, this is not the true statement. Why? Because elected member of the legislative assemblies of different states take part in the election of the President, and if some state legislative assembly is not in session, I mean if it is dissolved totally and there has to be re-election which has to take place, and during that time the presidential election takes place, it will have no effect on the presidential election. That simply means dissolution of a particular state legislative assembly will be no issue and will not stop in any way the election of the President of India. I hope you have got it. So this is a wrong statement again. Now third one, when a bill is presented to the President of India, the Constitution prescribes time limits within which he or she has to declare his or her assent. So there is no time limit given. Okay, there is no time limit provided for the assent of the President, not even in the money bill. There cannot be a time limit. Okay. The President can keep the money bill suspended if he wants. Same for the ordinary bill, same for the constitutional amendment bill. There is no time limit provided for the President to give his assent. Although the money bill has to be passed by the Parliament within 75 days. It has to be passed by the Rajya Sabha within 14 days. And if Rajya Sabha does not do anything within 14 days, it is deemed to be passed by Rajya Sabha. But no such thing is provided when it comes to the President of India. That simply means there is no time limit for any kind of consent which has to be given by the President. So this statement is also not true. So none of the statements are correct. Move on to sixth. Consider the following statement in respect of election of the President of India. The members nominated to either House of the Parliament or the legislative assemblies of the state are also eligible to be included in electoral roll. So it's basic knowledge that only elected members of the Parliament and the state legislative assembly take part in the election of the President of India. No nominated member takes part. When the President is impeached, during that time a nominated member can also vote in the impeachment motion, but not in the election of the president. Okay, so there are around 12 people, 12 members of parliament who are elected in the Rajya Sabha. 2 Anglo-Indians were nominated, 12 nominated members, and 2 Anglo-Indians were nominated in the Lok Sabha. This provision has been recently removed. So there are practically no nominated members in Lok Sabha, whereas there are 12 nominated members in Rajya Sabha. All those people do not take part in the presidential election. It is only the elected members of the legislative assemblies, elected members of the parliament. Okay. So this is not a true statement. Higher the number of elective assembly seats, higher is the value of the vote of each MLA of that state. Now, value of vote. If you have to calculate the value of vote of each MLA, how can you do it? By the simple formula that the population of the state has to be written, which has to be divided by the number of elected MLAs in that state. Elected MLA multiplied by 1 upon 1000. This is how you calculate the value of a vote of a MLA. So if it is the state of Uttar Pradesh, the population of Uttar Pradesh and the elected members in the Legislative Assembly of Uttar Pradesh needs to be filled in. If it is Madhya Pradesh, population of MP and the number of elected MLAs in MP. So you will get the value of a vote of MLA. Now what do you learn from this? That the value of MLAs of different states are different. So if a member of Legislative Assembly from Uttar Pradesh will have a particular value to his vote, assigned to his vote, the member of Legislative Assembly from Madhya Pradesh will have another value assigned to his vote. But the member of Legislative Assembly from Uttar Pradesh, all the members will have the same value assigned to their votes. So this is an important thing for us to understand. Higher the number of elective assembly seats, higher is the value of the vote of each MLA. This is a wrong statement. Why? See, the elective MLAs are written in denominator. For the value to be greater, the population has to be greater, not the number of MLAs. I hope you are getting it. It's a mathematical formula which you should understand to solve this question. The value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. So it is not pre-decided. It is not predefined. Okay. If the population of Kerala increases and becomes more than the population of MP, the value of vote of MLAs from Kerala will be more than that of MP. So it is not predefined. So this statement also is not correct. Moving on to the fourth one, the value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh. Why? There is a reason given. Because the ratio of the total population to the total number of elective seats, total population to the total number of elective seats of Puducherry is greater as compared to Arunachal Pradesh. That simply means this ratio in the case of Puducherry is greater. And if it is greater, the value of the vote of MLAs will be greater. So this statement is the statement which is according to the formula. This is not something which is predefined like this statement, but it is a formula based statement. This statement is actually explaining this formula with an example of Puducherry and Arunachal Pradesh. So this statement is a correct statement and only one is correct. Rest all of them are not correct. Going to the seventh one. No criminal proceeding shall be instituted against the governor of a state in any court during his term of office. This is true. If you see Article 361 of the Constitution of India, this provides the immunity from criminal charges to the President of India and to the governors of the state. So this is a true statement. emoluments and allowances of governor of a state shall not be diminished during his term of office. This is also a correct statement, hence both of them are correct. Moving on to the 8th one. Which of the following are the discretionary power given to the governor of a state? So, discretionary power. There are situational discretion, there are constitutional discretion. The President of India only has situational discretions, whereas the governor has both situational and constitutional discretions. Let's see. Sending a report to the President of India for imposing the President's rule. Now, this is a constitutional discretion given to the governor of a state. Appointing the ministers. Now, this is not a discretion. He has to appoint the ministers on the aid and advise. Okay, and when he is appointing the minister, he advises the chief minister of the state advises him to appoint the minister. Okay, so this is not a discretion given to the governor. Reserving certain bills passed by the state legislature for consideration of the President of India. So, reservation of certain bills. This is a discretion given again to the governor. Making the rules to conduct the business of the state government. Of course, this is also true. Both the President and the Prime Minister makes the rules for the efficient administration of the governments. President makes it for the central government and state, the governor makes it for the state government. Now, we have to see which of them are correct. So, we have 3 statements correct, but they have to match with the options. So, which one we can eliminate? Option number 2 will be eliminated. So, this is not our option, this is not our option, and this is not our option. 1 and 3 are correct. Sometimes you will have statements where more than 2 or more than 3 will be correct, and in the option you will not find the correct match. But then you have to understand one thing about prelims examination, that you have to match all the statement with the options given here. Okay, so elimination method comes handy in these kind of questions. If you eliminate statement number 2, because clearly this is not the discretion provided to the governor of a state, you can easily eliminate option A, option C and option D, and the left out last option B will be the correct answer. Moving on to the question number 9. With reference to the election of the President of India, consider the following statement. The value of vote of each MLA varies from state to state. So, we have seen the formula. Value of vote of MLA. So, the population of the state upon the number of elected MLAs, total number of elected MLAs in that state multiplied by 1 upon 1000. So, if the population of UP is filled here, then the number of legislative assembly seats will be filled here. Elected MLAs will be filled here, and then you can find the value of the vote of one MLA of the state of Uttar Pradesh. Now, see, in the light of this formula, read the statement. The value of vote of each MLA varies from state to state. Yes, why? Because the population varies from state to state. The number of MLAs, elected MLAs, varies from state to state, and hence the value of MLAs, the vote of the MLAs will vary from state to state. They will not be same, but they will be same for the MLAs of the same state. अगर यूपी के एमएलए हैं तो उन सब के वोट्स की वैल्यू सेम होगी, बट यूपी के वोट्स की वैल्यू एमपी के एमएलएस की वोट की वैल्यू से डिफरेंट होगी. दिस इज a critical thing which you should understand, and please learn this formula. It's an important formula. This was asked in 2018, may be asked again. The value of vote of MPs of the Lok Sabha is more than the value of the votes of MPs of the Rajya Sabha. Now, this is the value of the vote of MLAs. To calculate the value of the vote of Member of Parliament, there is another formula. The value of votes of all the MLAs of the country, total value total value of all the votes of all the MLAs of the country, and in denominator you are going to write totally elected members of the parliament, means elected members of Lok Sabha plus the elected members of Rajya Sabha. This is how you get the value of vote of one MP. So in the light of this formula, try to read the statement again. The value of vote of MPs of the Lok Sabha is more than the value of the vote of the MPs of Rajya Sabha. This is a wrong statement. Why? Because the value of the votes of MPs of Lok Sabha and of Rajya Sabha will be same. Why? Because we have to add both of them and keep it in the denominator in this formula. So this particular value which will come out will reflect the value of the vote of member of parliament. Does not matter the member of parliament is from Lok Sabha or Rajya Sabha. So only statement number 1 is correct. Last question. With reference to finance bill and money bill in the Indian Parliament, consider the following statement. When the Lok Sabha transmits the finance bill to the Rajya Sabha, it can amend or reject it. Yes, with the finance bill, the Rajya Sabha has the power because this is considered just like an ordinary bill. It can be introduced in the Rajya Sabha, it can be amended by the Rajya Sabha, it can be rejected by the Rajya Sabha. But such powers are not extended to Rajya Sabha in the matter of money bills. Money bills are those bills which are mentioned in Article 110 of the Constitution of India. They deal with taxation, borrowing and expenditure of the government. Taxation, borrowing and expenditure. And all the other matters related with finances are covered under finance bill. So these money bill is very important, and the Lok Sabha has the overarching power over Rajya Sabha in the matter of money bills. It has to be introduced in the Lok Sabha on the prior recommendation of the President. But finance bill is just considered as a ordinary bill, and hence it can be amended or rejected by the Rajya Sabha. This is a correct statement. So when the Lok Sabha transmits the finance bill to Rajya Sabha, it can amend or reject the bill. When Lok Sabha transmits money bill to Rajya Sabha, it can amend or reject the bill. It can only make recommendation. So it cannot. When Lok Sabha, after passing the bill, and which bill they are talking about in this statement? Money bill. So after the Lok Sabha passes the money bill and sends the money bill to the Rajya Sabha, does Rajya Sabha have the power to amend that bill, reject that bill? It cannot amend or reject. Till here it was alright. But it can make recommendations. Is this correct? Yes, this is correct. Only recommendations can be made by Rajya Sabha. So when Lok Sabha transmit money bill to the Rajya Sabha, it cannot amend or reject the bill. It can only make recommendation. The Rajya Sabha can only make recommendation, and it has to make recommendation within 14 days. If it does not make any recommendation and does nothing with the bill within 14 days, then it will be deemed as passed. We are talking about money bill, okay? And not necessarily the recommendations made by Rajya Sabha will be accepted by Lok Sabha. That's also not true. Okay. Now, the third statement. In the case of disagreement between the Lok Sabha and Rajya Sabha, there is no joint sitting for money bill. So, of course, there is no joint sitting for money bill. Similarly, there is no joint sitting for the constitutional amendment bill. Joint sitting takes place only when you consider the ordinary bills. But a joint sitting becomes necessary for finance bill, because finance bill is considered as an ordinary bill. There will be a joint sitting. So this is correct statement. So all of them are correct. So thank you very much for joining me in this session. We are going to come up with different subject tomorrow, and this PYQ series is going to help you to understand the trends of UPSC, from where UPSC asks question, what kind of question UPSC asks from different topics. It will help you a lot to streamline your preparation according to the UPSC examination. So thank you very much for joining me, and have a nice day. Jai Hind.